Mensah, chairperson, representing the first respondent. Mr. Peter McMahon, my lords, is representing the second respondent. May it please your lordships, I appear for the petitioner, and with me my learned friend Tony Litter. May it please my lords, Justin Amenvo appears for the first respondent, with me A.A. Somoa Asamoah.
If it pleases your lordships, I could on behalf of the second respondent. My lords, with me are my learned colleagues Frank Davis, Kweku Estrefi, and Yao Opong.
My lords, we have before you a motion on notice for an order for production for inspection of documents, in respect of which a request for inspection was served on the first respondent. My lords, we have this morning been served with affidavits in opposition filed this morning. By both respondents. And I take it that your lordships are granting them leave to file it out of time. I would have no objection to them asking for you to file it out of time, just for the record.
Council, it appeared when we were here yesterday, yes, they claimed that they were served just yesterday, I remember. And even some of us had your copy of the motion.
Yes, I don't have a, yes, I'm aware of it. All I'm saying is I will not object. I just wanted for the record for it to be clear that, because your lordships have in the past indicated that if we do anything that's contrary to your order, we need to. We can proceed. If your lordships are satisfied,
let's proceed.
Let us proceed. Let us proceed. Lords, I move in terms of the motion paper and the supporting affidavit. My Lords, we filed the request on the 19th of January. And my Lords, this is a situation in which, by virtue of Rule 5 of CI 16, we believe that this court essentially adopts CI 47. And therefore, in respect of CI 47, it is Order 21, Rule 9. As we indicate in our Exhibit Inspection 2, we filed a search which indicates that there has been no response whatsoever to the request that we made to the first respondents. Now, my Lords, there is no question that the first respondent is the person with lawful custody of the documents which we seek to inspect. And it is also quite clear that these documents are public records in the custody of the first respondent. Your Lordships will note that each of the categories of documents that we refer to in paragraphs 1 to 5 of the request are originals. Of constituency presidential election results in accordance with the various forms that are required to be exhibited. So what we're asking for are originals of these documents. And in paragraph 6, what we are asking for also has to do with the records of the alleged update to the purported declaration. That alleged update is Exhibit B attached to the witness statement of petitioner's witness 1. Your lordships will see that the figures in respect of that alleged update including the figures of total valid votes cast are different from the declaration that was made on the 9th of December, and which we have provided evidence of as an attachment to the witness statement of PW1 marked Exhibit A. That is a video recording that your lordships, that the court saw. And there is, again, no dispute that, for instance, the figure of total valid votes cast in Exhibit B is 13,119,460. Whereas what the petitioner stated, what the first respondent stated, which is attached to the petitioner's witness number 1's witness statement at Exhibit A, what she stated was the figure 13,434,574. 13,434,574. So there is a conflict between those two figures to start with. But that matter is compounded by the fact that in Exhibit B, a figure is mentioned as what the chairperson of the first respondent inadvertently used, which is again different from what the figure that she actually used. The figure that is now contained in this purported correction is 13,433,573. So we have 13,434,574 on the 9th in declaration as total valid votes cast. Then we have a purported correction, 13,119,460, which purports to correct a figure in the declaration and uses yet another figure, 13,433,573. Now, my lords, the point about all these matters is that these figures are supposed to relate to documents that back the figures. They are supposed to relate to documents in the possession of the first respondent that can justify these numbers. These figures are not supposed to be just plucked out of thin air. They're supposed to be figures based on the backing documents. And your lordships will have noted that in our petition, we indicated that if you actually sum up, if you do the arithmetic in respect of the column where votes are attached to individual candidates, if you do that, the figure that you come to is again a different figure. That is 13,121,111.
Make it better.
Yes.
If you sum up in which document?
In our amended petition in paragraph 12. Our amended petition.
You said if you sum up.
If you sum up
from which table?
That is from what was read. What
was read from the video?
Yes. What was read from the video, Exhibit A.
Exhibit A.
That's right. So we basically listened, took down the numbers, and even though this 13,121,111 did not appear anywhere,
you actually sum up the figures mentioned in Exhibit A.
Then
come to
13,121,111.
Thank you.
And we state that in paragraph 12 of the amended petition. So that is a fourth figure. Now, your lordships will note that in the answer of the first respondent, that was filed on the 9th of January. In that answer, the first respondent now actually adopts the figure that we had calculated. And for the first time, the first respondent also states 13,121,111 for the total valid votes cast. So the figure that we have calculated becomes now the basis of the answer. The stone which the builders rejected has become the capstone of the answer of the first respondent. My lords, these are the plain circumstances which necessitate a reference back to original documents which are in the custody of the first respondent. So that there be a proper validation of what the correct number is. My lords, we simply cannot have a situation in which, as described by the petitioner's witness number 1, we still, as at today, cannot tell what the correct figures on the basis of which a declaration has been made publicly. We cannot tell what those correct figures are. We simply cannot tell. And my lords, the only way in which ultimately this court is going to have to satisfy itself in our respectful submission is by ascertaining from the first respondent what exactly its chairperson, who is a constitutionally mandated person, is using for her declaration. And your lordships also have before you a witness statement of the first respondent, which is sworn to by the chairperson, Mrs. Jean Adukwe Mensah, and that is filed on the 22nd of January. And there again, my lords, there is now reference made on oath. Well, I'm sorry, it's not yet on oath. It's not yet on oath. I'm crossing a bridge that I have not got to. But the witness statement, which is already before your lordships, has this number 13,121,111, and that witness statement provides no explanation of how in Exhibit B a different number to be corrected is given from the number that we all heard in the declaration. Yes.
Is that not in paragraph 11? Paragraph 11, the first respondent's witness statements. Is the explanation not there?
My lords, it is not, because, my lords, as I indicated, in the Exhibit B to the witness statement, the number that was given as being corrected is 13433 something something. It is not 13434,574. In the correction that was purported to be made, which I referred your lordships to, and I may go back to it again with your permission, that is the attachment to Johnson Asiedun Ketia's statement, and that is Exhibit B. Your lordships will see that it says the chairperson of the Electoral Commission inadvertently used 13433,573. That is different from the figure that I alluded to, and that is different from what she's referring to in the paragraph that your lordship has referred me to. So, my lords, the reality of changing numbers is inescapable in this election petition.
Mr. Chikata,
yes.
So these numbers are all related to either the total votes or the total valid votes?
That is correct. And CI 127 tells us how those numbers are supposed to be arrived at. CI 127 regulation 4410 requires an assembling and collation of results from the regions provided by the various regional collation officers as set out in Form 12. So, in the midst of the ever-changing figures, it is our respectful submission that there is a need not only to refer to the originals of what she herself purported to use, so that they can be compared to whatever documentation is available to us from the ground. My lords, there has also been, in this case, there has also been extensive cross-examination in respect of Exhibit C, which was struck out, but there was extensive cross-examination in respect of that exhibit. And therefore, my lords, I wish to make reference to that, because the cross-examination purported to show, the cross-examination of counsel for the first respondent purported to show that the two different documents for the Eastern region my lords, with respect, I never cross-examined on Exhibit C. The exhibit my learned friend might be talking about is Exhibit D, the one that is attached to their letter. My lords, I do take that correction. It's Exhibit D attached to the letter. Exhibit D. Exhibit D. As in Daniel. There was cross-examination by counsel for the second respondent of Exhibit C, which I will come to later. No, my lord. He cross-examined extensively on it. He did cross-examine on it. But my lord, I will start with Exhibit D, and I should not have said Exhibit C. Now, my lord, with Exhibit D, counsel cross-examined the witness extensively to show or to explain why one document which has a kind of a stamp, a blue stamp, why that document is different from the other document, and that's when you referred to Ainswanu and all that. Now, my lords, without going into all the details of the figures, I mean, it's clear that it was acknowledged that there were differences between those two. So what we are saying respectfully is that in order even to be clear on what was actually used by the first respondent in reaching the numbers that were ultimately totaled, in order to be clear about that, we would request to inspect the original document that she had. It is no response to say that we have both, simply because we have both documents, both what was originally signed even by our agent, and then another document that was not signed by our agent in terms of the regional summary for Eastern region. So it's no response to say that we have both, because that's precisely the reason why we need to know which one is the authentic one. And the only way to know the authentic one is if we are allowed to inspect. If we're allowed to inspect the originals that are presumably, counsel for the first respondent who put to the witness certain figures from a certain constituency and all that has had access to those originals, because otherwise he wouldn't put it to the witness. And counsel is only allowed to put to the witness what he has been instructed by his client. So without question, counsel has information which we are not in possession of simply by virtue of having these two contradictory documents, which are Exhibit D, which are attached to Exhibit D, which are attached to Exhibit D. And, my lords, it was explicit in the testimony that was provided by the second petitioner's witness that the agents of the candidate, the petitioner, had issues with some of these collation sheets and began to air them in the discussions to the relevant officials of the EC, and we are awaiting appropriate responses. Now, my lords, as I've said, Exhibit C was also cross-examined upon extensively, and a lot of arithmetic calculations were made in respect of Exhibit C. With different permutations of numbers. And we are saying respectively that what all that proves is that without knowing the authentic original documents on the basis of which the chairperson of the first respondent undertook her solemn constitutional responsibility, we are all in the dark. Yes, sir. My lords, we are conscious of the fact that in the election petition in 2012-2013, an application was made in a similar manner for documents to be produced for inspection. And the ruling of the court, which is found in 2013 Supreme Court of Ghana Law Reports at page, the special edition, at page 61 onwards. The ruling of the court states clearly why the lordships on that occasion did not grant the application. And I would respectfully refer to a passage at page 71 of the judgment of the ruling read by Ladyship Sophia Adinira. And she says as follows: in the circumstances, we hold that the petitioners are sufficiently and well informed about the election results, which had enabled them to mount this petition on grounds of malpractices in 4,709 polling stations based on the contents of these duplicate documents in their possession. In that case, the petitioners mounted the petition on the grounds of 24 categories, as they put it, of malpractice in initially 4,709 polling stations. It became 11,000 by virtue of subsequent amendments, 11,000 and more. And so what the court was there saying is that the petitioners themselves have already put forward, in support of the case, documents that they had confidence in. They had put them forward. And therefore, to ask to inspect documents when you yourself have said, we are putting these forward, and this is the basis of our case, that is contradictory. In this petition, my lords, we have not put forward results or malpractices in 4,709 polling stations. In this petition, we have put forward the words of the declaration of the chairperson, the returning officer, the only constitutionally mandated body, or person, I should say, not even body, the only constitutionally mandated person to exercise that responsibility. And so clearly, the rationale, the ratio decidendi of that case cannot relate to what we are dealing with in this petition. And her ladyship goes on to say that the affidavit in support of the application does not disclose any need for the inspection and making photocopies of the originals of the documents. My lords, nobody can say that in this case we are not disclosing any need for the inspection. In a situation where we have changing numbers, and in a situation where to this day we are in no place to state a definitive number. In those circumstances, in our respectful submission, it is actually even in the interest of the first respondent, in terms of transparency, in terms of fairness, it is actually in their interest to make available. That is why, frankly, we did not expect that we have to make this application before that request is granted. We honestly thought that this was something that would be resolved and we would go and have the opportunity to inspect. There are clear provisions in the rules of court within a reasonable time and within reasonable circumstances, and we cannot obviously flout those circumstances. So this is something that could have been resolved, you know, in a very straightforward manner by enabling that inspection to take place without having recourse to orders of the court. But we have not had even the courtesy of an acknowledgement of our request, and therefore we are obliged to seek the orders of the court in order that we can achieve what will enable us to have a fair hearing of the petition that we brought to this court. Now, if there's nothing to hide in terms of transparency around these originals, it's difficult to appreciate why an inspection could not have been granted in the course of the last 14 days or so since we filed. 12 days to the end of January, so about 15 days. If there is nothing to hide, I mean, if the interest of the first respondent is transparency, as has been indicated, then why would it be so difficult? Why would it be so difficult to allow access to the originals? We haven't come relying on our duplicates saying that they are the basis of our case. We've come relying on her own declaration. Her own declaration speaks for itself. So, my lords, in this situation, we require access to the originals, which we can then compare with what we have and try to get to the bottom of these ever-changing numbers. Now, my lords, the reference that I made to a fair hearing, my lord, is also anchored because we are saying effectively that this access to these documents is required for a fair hearing in this case, because it is not within the province of the first respondent just to pick and choose numbers from different sheets in the way they sought to do in cross-examining on Exhibit D. It's not within their province just to pick and choose and say, oh, this document which you have, it didn't include Ayenswanu. There's nothing on the face of the document which says Ayenswanu is there or not there. Nothing. And this one which you also have, which is supposedly about the same regional results, regional collation, that document has different numbers. And we just have to take it from them that Ayenswanu's 40,000 is what has led to the difference. Well, that is totally unacceptable, with the greatest respect. And Article 19(13) of the Constitution makes it clear that this court is required to give a fair hearing within a reasonable time. May I just, with your permission, read that article? An adjudicating authority for the determination of the existence or extent of a civil right obligation shall, subject to the provisions of this Constitution, be established by law and shall be independent and impartial, and where proceedings for determination are instituted by a person before such an adjudicating authority, the case shall be given a fair hearing within a reasonable time. Now, my lords, as I indicated, we are asking for a fair hearing of the petition that we have brought. And for that fair hearing, we are submitting that the matters that we have, the documents that we have sought access to are necessary documents in order to understand the case that is being put against us, with all its changes and permutations. And so it's our respectful submission. And my lords, I may just make a comment finally on 6. The request in 6, that is not dealing with originals that is dealing with records of the alleged update to the purported declaration. Now, my lords will observe that that update, Exhibit B to PW1's witness statement, that update is not signed by anybody. It's a press release, and we do know. Okay. Yeah. That update is not signed by the chairperson. It is not signed by anybody. And we do know, my lords, that the constitutional role that is assigned to the chairperson, both under the Constitution and under CI 127, that role cannot be delegated either to a media relations officer or to a deputy or any other person. It cannot simply be delegated. And therefore, how the records relating to that alleged update are things that need to be inspected, particularly when we have pointed out to your lordships that in that update itself, certain figures are put there which are different from what we all heard in the declaration. So some records are required, and no doubt there must be some basis internally for the alleged update, and that's the essence of what is in paragraph 6 as distinct from paragraphs 1 to 5. It's our respectful submission, therefore, that in the interests of justice, this application be granted. And I would also just conclude with what is provided in Order 1, Rule 2 of CI 47, that these rules shall be interpreted and applied so as to achieve speedy and effective justice, avoid delays and unnecessary expense, and ensure that as far as possible, all matters in dispute between the parties may be completely, effectively, and finally determined, and multiplicity of proceedings concerning any matters avoided. Indeed, this proceeding, in our view, is really quite unnecessary because it could have been dealt with expeditiously. My lords, I omitted one point in their response that I just want to comment on in one sentence. Both responses begin to raise issues about burden of proof in the case and so on. In our respectful submission, issues of burden of proof are irrelevant to the inspection of documents. The burden of proof in this matter is something on which no doubt we'll have occasion to address on different aspects. Whether the burden of proof is on us to do this or that, those are matters that at the appropriate time we'll deal with. But in their affidavits, essentially, they are laying claim to some view of burden of proof, which is legally very suspect, but on that basis, we are saying that this application should not be granted, and we feel there is absolutely no basis for that.
You refer us to Order 9, 1. Can we take a look at you refer to Order 21, Rule 9. Can we look at Order 21, Rule 11, and if you may address us on it? Since I believe the primary objective of this application is to determine the total valid votes cast. That's the primary objective. Your application, yes, is to determine the total valid votes. No.
We cannot be limited to just the total value. I'm sorry. Yeah. My lords, this application is not just the determination of the total valid votes cast, because the total valid votes cast goes back to whatever was happening at the regional collation, that is the Form 12 that is referred to, and about which there's been evidence that there was some dispute about that. So it is not just the total, it's also to do with the allocation of the votes. Your lordships will see that in the Exhibit D attachment that we have, there are differences in the allocations of the votes cast. So it cannot just be in respect of total valid votes cast. It cannot just be.
Can you look at Rule 11? Rule 11, sub-Rule 1.
Order 21,
Rule 11.
Rule 11. Production to be ordered only if necessary. Yes, my lord. An order for the production of any document for inspection or to the court shall not be made under any of these rules unless the court is of opinion that the order is necessary either to dispose fairly of the cause or matter or to save costs. And then 2, where on an application under this order for production of a document for inspection or to the court, privilege from the production is claimed or objection is made to the production on any other ground, the court may inspect the document to decide whether the claim or objection is justified. I don't believe that privilege is an issue here.
Referring to 1?
Yes. In 1, we have addressed you on the necessity, and we have addressed you by referring even simply to the attachment to Exhibit D, which has been the basis of a lot of cross-examination here and the basis of a lot of explanation from counsel. But that Exhibit D itself, in our respectful submission, shows the necessity for knowing what is the original document on the basis of which we must choose one or the other. What is the original document? That is my submission.
Secretary, I have a question. When you go to inspect them, what will you be doing?
Well, we'll be comparing them with documents that we have, which we regard as authentic, to see whether indeed they are the same. That's what we'll be doing.
But you don't see the need to tell us what you have as your valid vote?
No, we do not have the need, because we are not the returning officer, with the greatest respect. We are not the returning officer. And my lords, with the greatest respect, this is quite an important point, because His Lordship Justice Apal did ask certain questions in relation to PW1, and in our respectful submission, those questions are completely irrelevant to the issues that have to be dealt with. Because the question whether he has documents or
my
not...
lords, if I may be heard on this. My lords, I think counsel should argue the application before he... Yes, but the question had nothing to do with what Justice Appa said.
Let me answer myself.
No.
Please. Mr. Chikata, please, that is your opinion. So you keep it to yourself.
Yeah,
whether the questions I asked were irrelevant or not, that is your opinion.
Yeah, but my lord, I need to explain why I'm saying they're irrelevant, so that I can fully answer the question. Because the question relates to the same position that your lordship took. The question relates to that. So I need to be heard on why I say that they're irrelevant, because I do not say that lightly. I do not say that lightly. I do not say that lightly. The questions are irrelevant because we have brought a petition here on the grounds of a declaration that was made purportedly about elections held on the 7th of December. The declaration stated a figure. We all heard it, 14,300 and 400 and all that. We all heard it. That declaration to this day is the only declaration that has been made. Johnson Asiedu Nketia is not the returning officer of the election of 7th December. That is all. We are opposed to this application. And my lords, we rely on all the positions in the affidavit in opposition. My lords, under Article 64(1) of the 1992 Constitution, the petitioner has had 21 days from the date of the declaration to file this petition. Lords, we have not been told in this court that between the time of the declaration to the time the petition was filed, any such request has been made. Lord, secondly, the question is asked, why is this application being made on the 34th day after the petition has been filed, when hearing is well underway? My lords, if you peruse exhibit inspection 1, the document filed purports to give the first respondent 3 days from the date of service to comply. Lords, with the greatest respect, there is no such rule of this court under which this application was made, or even under the High Court rules. Yes, but my lords, even so, it talks about 14 days. Mutual discovery talks about 14 days, my lords. Lords, I say this because under Rule 5 of your rules, oh sorry, my lords, of the Supreme Court rules, with your kind permission, if I may read, where provision is not expressly made by these rules regarding the practice and procedure which shall apply to a cause or matter before the court shall prescribe the practice and procedure that, in the opinion of the court, the justice of the cause or matter requires. And lords, there have been several authorities on this point that it is the court that you make an application to for guidance in this matter. Lords, with respect, if I may refer you to the case of Cogles Ghana Limited number 2 versus Atier number 2, 2003-2004, Supreme Court of Ghana Law Report at page 75. Lord, with respect, Adre DSC, speaking for the court, said this, and with your kind permission, if I may quote it. I hold a view that the application before us cannot be entertained under Rule 5. In my opinion, where a party has difficulty or is in doubt at what steps to take, where there are no express practice of procedure provided, the party must apply to the court for directions rather than, and this is my emphasis, rather than arrogate to himself the powers given to the court under Rule 5.
Yeah, these are amenable.
Yes, my lord.
You see, he came under mutual discovery. That is order 21-1. Yeah. Then when you look at the proceedings, we've gone beyond that because there was no response from you. And when you do not, allow inspection or whatever of documents, then you can resort to an application under 21(9).
Yes.
And this is the application you are determining. Yeah. So look at the Cogles case again, whether you can look at 5 of the CI system and apply it to the circumstances.
So my Lord, I refer to the Cogles case in order to make the point of the timing of this application.
The timing?
Yes, my lords. The timing of this application.
Do you have any time frame after the failure of mutual discovery?
My lords, when you are proceeding.
No. I respond to the question. What I'm saying that beyond mutual discovery, do you have any time frame set down under Order 21?
No, my lord, you have to apply to the court.
And this is the application you are determining.
Yes, my lord. So the point is that the point is that where CI 99, under which the presidential election petition is filed, talks about timeousness. Then, when you make an application at a particular point in time, in responding to the application, with the greatest respect to the court, we are entitled to make the point as to the timely nature or otherwise of the application. Lord, the second point I wish to make is that the petitioner has failed to prove that the production for inspection by the first respondent is necessary in these circumstances. Lord, this is because the witnesses themselves who came to testify on behalf of the petitioner themselves admit that they have the documents. And Lord, the way this process is that once the document is filled out or the agents are given the carbonized copies, and we did ask them, both of them, that do you have the documents? They said under oath that we do have the documents. So therefore, if you do have the documents, on what basis is this application being made? Now, Lord, furthermore, it's our submission that the situation is that the petitioner has failed to provide any evidence in support of his petition. And that is why, at the end of the cross-examination of the petitioner's witnesses, this application will be brought in order to give them the opportunity to lead further evidence. I do not believe that it has been the practice of our courts that evidence is led in piecemeal. Evidence cannot be led in piecemeal before the High Court, how much more the Supreme Court. So, my lords, it is our submission that for these grounds, and of course, they bear the burden of proof to provide evidence sufficiently for the burden to shift. They have it, and having failed to do that, they cannot, at this late hour, come and make this application for documents which the witnesses themselves admit are in their possession. That is our submission, my lords.
My Lord, we believe that at the heart of this application is the question of which party bears the burden of persuasion and the burden of producing evidence. Now, my lords, I say so because the petitioner, by the admission of his own witnesses and by law, has photocopies of all carbonized copies of all the processes from the polling station right up to the regional level, and then even to the National Coalition Center. They have copies of all the documents through carbonized copies. Therefore, where the petitioner raises a question about the authenticity of any document, he must first produce what he has and show that what he has is different from what the other party has. Secondly, if it is in respect of the declaration, the petitioner has all the documents that will enable him sum up the results, the national results of all the candidates. He has the carbonized copies of relevant documents that will enable him sum up the total number of valid votes he got, the total number of valid votes the second respondent got, and the total number of valid votes the other candidates had. My Lord, the petitioner, for reasons best known to himself, has refused to present this before the court when he bears the burden of proof. He has refused to take any steps to meet that burden. He has refused to produce any documents to meet his burden of producing documents. Then he turns round and under this guise of application to produce evidence, he's saying that produce a document. He's trying to garner the evidence that he used to prosecute his case. My Lord, this, with all due respect, is a totally misconceived procedure. My Lord, let me say again that it is not as if the petitioner is saying that from the documents I have, the documents that the EC is producing is not the right document, and therefore we want to see the original, because we have the exact carbonized copy of what the EC has, and what it's producing is different from what we have. It's not saying that. Rather, the application confuses authenticity, because you are questioning the photocopy as not the original, the carbonized copy as not the original. And where the document is authentic, but you are taking issue with the contents, it's a different matter. If the document is authentic and you are taking issue that the content, you have a problem with it, it's a different matter from saying that it is not authentic. You can only raise the question of authenticity if you have some other document which is showing that this cannot be the authentic document. And say that nobody can quarrel with the petitioner where he says that I have problems with the content of the document. If you have problems with the content of the document, produce the carbonized copies which will show that the contents of the document are wrong. And that is why, my lords, at the heart of this application is an attempt to shift the burden of proof and the burden of producing evidence onto the respondents. And that is never possible in any court of law. My lords, again, we wish to make it very clear that it is not the number of times that counsel refers to transparency, that would make his case that things are not transparent. He needs to provide the evidence of lack of transparency and not just the verbal statement about transparency and repeating it over and over again. Then again, my lords, the petitioner makes a very curious statement about fair hearing. My understanding of his submission is that he's using fair hearing to conjure away the burden of proof. Conjure away. He's using the right to a fair hearing to My lords, with all due respect to your lordship, with all due respect to your lordship, I think what I'm saying is appropriate, given the context. I'm saying, my lords, with all due respect, that the applications seeks to use the right to fair hearing to conjure away the burden of proof and the burden of persuasion. These are very fundamental issues in a trial process. He cannot shift the burden of proof when he has not led any evidence which compels us to lead evidence in response. He has not adduced any evidence, much more met the burden of proof. That is all the time on him. So, my lord, if this is the reason for its application, my lord, it is a misconceived application. My lords, what makes it worse, my lords, is that he has not met the basic conditions set out in Order 21, Rule 11, 1. 21, Rule 11, 1. 11.1 of CR 47, which reads, with your permission, as follows. An order for the production of any document for inspection or to the court shall not be made under any of these rules unless the court is of the opinion that the order is necessary, either to dispose fairly of the cause or matter or to save costs. My lords, it's our conviction that the counsel has not shown in any way whatsoever the necessity of this application. Furthermore, he has not demonstrated how this will aid the fair disposal of the application or save costs. It will not help save costs because indeed, if the application is granted, it will rather increase the cost of litigation. It will not promote a fair disposal of this this petition because the application is misconceived. Being misconceived, it cannot promote the fair disposal of the cause or matter. Now, we believe that counsel was right when he referred to the decision in the Supreme Court of Ghana Law Report Special Edition 2013, where at page 70 thereof, the court, speaking through Sofadino JSC, made the following points, and I quote, The guiding principle, page 70, my lords. My lords, counsel was right in the quotation, but it was completely wrong in the gloss and interpretation he sought to put on the text. But I read the text. Quote, the guiding principle in the instant application, which is an application for production of documents or inspection, is whether the order is necessary, either to dispose fairly of the cause or matter or to save costs. Now, the court observes the result collation forms and the declaration forms are public records in the official custody of second respondent, Electoral Commission. The petitioners, as well as the first and third respondent, like all other political parties and independent candidates that contested the December 2012 presidential elections, were given duplicate copies of the same documents through their representatives at the polling and collation centers and so-called strong room of the Electoral Commission in accordance with the provisions of public election regulations. It is our thinking that where a party is already in possession of a copy of a document mentioned in another party's pleading, it is unnecessary to apply or for the court to make an order for the inspection and making copies of the document in question. Then the court makes a very important point. By virtue of the Evidence Act 1975, NRCD 323, Section 166, the duplicate copies of these documents are admissible to the same extent as the originals in the custody of the second respondent, that is the Electoral Commission. Now, the court continues. Petitioners have not raised any concerns about the duplicate copies given them at the collation centers. And they can't raise those concerns because they have not introduced those documents before your lordships. So they cannot raise concerns. So that is why this application is thoroughly unmeritorious and should be dismissed as such.
My lords, may I just, with your leave, I just wanted to indicate in respect of the point, may I, with your leave? Yes, my lords, it's been suggested that we must first produce what we have before we ask for something. There's nothing in Order 21 that...
My lords, that's not what I said. It should not misinterpret me.
That was... And my lords, as far as the carbonized copies being available are concerned, that's exactly the problem. We've indicated with examples that we are confronted with a situation which needs to be clarified.
No, my lords, he can only respond on legal issues. He's introducing facts.
Sit down. Please sit down. We will have...
All right.